This is a job that comes with a lot of tragedy. That's something that those of us who do it know, and frankly, in many cases are used to. But there are cases that stand out over the course of your career. This case stands out even among those. Because tragedy as a word doesn't really even touch what happened here and what this family and community has been through, what they will continue to go through every day when they wake up without Monique. And so with that, Judge, we'd ask that you impose the mandatory sentence in this case of life in prison without the possibility of parole.
All right, thank you, Ms. Starkey. All right, Ms. Gadd.
The defense has nothing to add. Thank you.
All right. Anything, does your client wish to make any statements? He certainly has a right to make a statement. I'm happy to hear anything he has to say, or he can choose not to make any statement.
Mr. Wiggins does not wish to make a statement at this time.
Okay, thank you. I want to begin by acknowledging the family members and friends of Ms. Baugh who are here and those who delivered victim impact statements. I do appreciate that. It's helpful for the court to hear from family members in all cases, and I appreciated their efforts to share their views and memories of Ms. Baugh. Mr. Wiggins, as you know, the jury found you guilty of aiding and abetting the murder of Ms. Baugh, her kidnapping, and the attempted murder of John Mitchell Momo. Over the course of the 3-week trial, I did have the opportunity to see and hear all the evidence in this case, and I'm now well aware of the full scope of your criminal conduct. I fully agree with the jury's decision in this case in finding you guilty of those charges. Based on my view of the evidence, it's clear to me that you are the criminal architect of a cold, calculated, and cruel criminal scheme that led to the kidnapping and ultimately to the tragic, senseless, and brutal murder of Ms. Baugh and the attempted murder of Mr. Momo. I guess I'll never fully understand the full reasons behind that, but I don't know that that necessarily matters. Life is precious, but you showed no regard for the lives of Monique Baugh or John Mitchell Momo. You devised and directed the criminal plot that resulted in Ms. Baugh's execution-style murder in a cold and dark alley on New Year's Eve in 2019. Because of you and your co-defendants, 2 little girls will grow up without their mother, and Monique's mother, daughters, friends, family members will never be able to hug her again. I know the sentence I'm imposing today will never fully heal the pain and loss of the family members and friends of the victims. I can only hope that the jury's verdict in finding Mr. Wiggins guilty of these crimes and the sentence I'm imposing today will bring some sense of closure and possibly start the healing process for the loved ones of Ms. Baugh, who lost a daughter, a mother, a granddaughter, a cousin, and a friend. Based on the jury's verdict, Mr. Wiggins, I'll begin with count 3. Based on the verdict of the jury, you are found guilty of aiding and abetting kidnapping to commit great bodily harm under Minnesota Statute 609.25.1, to commit great bodily harm or terrorize. In the judgment of this court, you are convicted of that offense. The court finds that a firearm was used in the commission of this offense. You are committed to the custody of the Commissioner of Corrections for 189 months with credit for 1,981 days. This sentence is to run concurrent with your federal drug sentence. If you have not already provided a DNA sample, you must provide one as required by law. You are prohibited from possessing firearms and ammunition for the remainder of your life. I order that you pay a fine of $50 to be paid from prison wages, and to pay the mandatory surcharge of $78 to be paid from prison wages as well. I'll turn next to count 2. As to count 2, based on the verdict of the jury, you were found guilty of aiding and abetting the attempted murder in the first degree under Minnesota Statute 609.185A1, and the judgment of the court is you are convicted of that offense. The court finds that a firearm was used in the commission of this offense. You are hereby committed to the custody of the Commissioner of Corrections for 240 months with credit for 0 days served. This sentence is consecutive to the sentence already imposed for count 3 and any other sentences imposed. Again, a DNA sample is required, and you are prohibited from possessing firearms ammunition for the remainder of your life. Turning finally to count 1. Based on the verdict of the jury, you are found guilty of aiding and abetting murder in the first degree under 609.185A1, and the judgment of this court is that you are convicted of that offense. The court finds that a firearm was used in the commission of that offense. You are committed to the custody of the Commissioner of Corrections for the remainder of your life with credit for 0 days served. This sentence carries with it no possibility of release or parole. This sentence is consecutive to the sentences already imposed for counts 3 and count 2 and any other sentences already imposed. Count 4 shall remain unadjudicated pursuant to Minnesota Statute 609.04 as a lesser included offense of count 1. Again, in count 1, you need to provide a DNA sample as required by law, and again, you're prohibited from possessing firearms ammunition for the remainder of your life. I will order restitution to be paid consistent with the previous restitution order. Ms. Gadd, have you seen that restitution order?
I've seen the amount on the docket, but I haven't seen the order itself.
And Mr. Filipski did just email both the court and council an updated proposed copy.
Any objection to the restitution order, Ms. Gadd?
Give me just one moment to review it. No objection.
All right, I will order restitution and make a finding that Mr. Wiggins does have the ability to pay. The funds will be taken out of prison wages. There are two amounts. One is $11,917.88. The other is $61,489.88. Is that the order that you received, Ms. Gadd?
Yes, that's the one that Mr.
So I think I have to re-execute this. This is a new sentence, so I will sign this order today, ordering the restitution in those amounts. And I'll date it today's date. All right. Anything further?
Nothing
Be the
to
party.
say. Thank you, Your Honor.
Nothing for the defense. I did file a motion to withdraw as counsel. I'm not sure if Your Honor wants to address that today or after today.
Maybe address it later.
Okay.
After today? I think I did not see that, so I didn't. Why don't I look at it and then I can address it after this hearing?
Absolutely.
Okay. All right. Thank you.